Hello, everybody. Good afternoon. My name's Stephanie Godel. Most of you know me at this point. I am your 2020 president of the Pacific West Association of Realtors. We are beyond excited today to have a special guest for our legal briefing for today. So just a quick little bio for those of you that don't know Gov Hutchison. Gov Hutchinson is the Assistant General Counsel of the California Association of Realtors. He has been with C.A.R. since 1985 and manages C.A.R.'s member legal services program in Los Angeles. He advises realtors through the hotline on all aspects of real estate law, and he trains and supervises other hotline attorneys. Gov received his bachelor's degree in history from Princeton University and his Juris Doctorate from the University of Pennsylvania. He has written for the California Real Estate Magazine, co-authored C.A.R. continuing education courses, and is a master instructor for the education division of C.A.R. with certification from the California Department of Real Estate. Phew!
Yeah.
So, Gov is here today to give us just a legal briefing on what's going on, both COVID and not COVID. So, Gov, I'm going to turn it on over to you. And as a reminder, any questions you guys have, please put it in the Q&A box and we will do our best to address those.
All right. Good to be here. Do you know tomorrow is my 35th anniversary at C.A.R. Can you believe that?
That's crazy. Congratulations.
Thank you. I remember life without computers and cell phones. Some of you don't remember that. Anyway, the world has changed, and the world has really changed in the last 2 months. Not everything I'm going to talk about today is related to the coronavirus, but most of it is, because we're in a different legal environment right now. It's not going to be like this forever, but we got to deal with what we got to deal with right now. Plus, things are changing constantly. As recently as this week, there's some major changes, which I'll talk about. Okay, so anyway, let's start with a quick review. 2 months ago, you remember when this whole thing started, and some of you remember the first like 3 or 4 days, real estate was not an essential service. Mm-hmm. We're all petrified, what are we going to do? And then about 4 days in, we got the governor to agree, or the indirectly to agree that real estate is an essential service. That's good. But not business as usual real estate, just you can do things. What happened was the governor issued an order that incorporated these federal essential infrastructure guidelines, which said you were essential. And then there's some CDC guidelines too, meaning that you can't do whatever you normally used to do. You couldn't do open houses, and you couldn't do multiple, a lot of people in the property at the same time. Everybody should have social distancing and wear the gloves and wear the mask and all sorts of rules. And we took all that stuff and converted it into a document called Best Practices. Some of the Best Practices document was sort of required by law. Some of it was just sort of suggestion. But most people have been following it all along these last 8 weeks. And we also created a form, the PEAD, that everyone is supposed to sign when they're entering properties, agreeing to follow the rules, et cetera, et cetera, et cetera. And people have been asking me for 8 weeks, is this form mandatory? And I said, not specifically mandatory, but most of the stuff in it is pretty much required. And the rest of it is a really good idea. And most people have been using it. Okay, so that's the first thing that happened. Then what happened is a lot of places like Orange County in general and Long Beach and all these different places came up with their own rules, right? Sort of modifying the basic state rule. And as you know, some of the more specific rules were stricter than the state rule, but then most of that, in the meantime, over the last 8 weeks, most of the cities and counties have made things a little bit, have sort of loosened some of their rules, like Long Beach certainly did. So it's pretty much all in line with the state rule, because for a while there, remember, you couldn't show houses unless they were vacant and things like that. Mm-hmm. Well, that's pretty much gone away. But here's what happened last Thursday. The state of California, remember, originally this was just based on the governor's order incorporating federal guidelines. Well, the state OSHA and the state DRE and the state Department of Public Health finally came out with their own rules after 8 weeks. And this was in line with the governor moving us from stage 1 to stage 2. So it all sort of happened Thursday night. So what did the state say? Well, they came out with guidance for real estate. And guess what? They pretty much copied most of our best practices. So what we've been saying all along you should do, now you have to do, okay? Pretty much what the state said is now a requirement that we can all live with because we've all been doing it. Couple of things they added a little bit to make it a little bit tougher, I guess. One of them is occupants shouldn't be there when you show the property, right? Make sure that they're not there. They don't have to be vacant, but as long as make sure they're not there. Also make sure little things like good ideas like when you show a property, you should leave all the doors open, right? So no one has to open any doors when they're in the house. And you should write down, and you should wipe down not just the surfaces, but things like banisters and handrails. Okay, we can all live with that. Then a couple more things it says. It says every company who does real estate, they sort of have to adopt their own COVID-19 prevention plan. Well, guess what? That's the best practices. If you use the best practices, you've got a plan. So that's good. Then the second thing this new order says is every company has to come up with some rules about showing properties and stuff like that and require people who enter the property to sign them. Well, we're ahead of them already, right? We got the PEAD form. So the PEAD form is now not just a good idea, it's really required. In other words, the state is saying you need to have people sign some document before they enter the property. So I think you've all been doing that already, but now you really have to make sure you do that. And the third thing that's kind of interesting is that they say you have to post. Let's say you're showing a house, you got to post on the front door or next to the front door a copy of the PEAD form, basically telling anyone who's coming into the house that, you know, the occupants, that you have to follow these rules. Now, to me, that's kind of silly because if you've already signed the PEAD form saying you're going to follow the rules, and the seller already signed their, and the listing agent signed one also, it's kind of redundant to have to post it, but you do. That's what the new rules say as of last Thursday. You also need to do it. Now, it doesn't say this in the best practices yet because we haven't updated the best practices yet to comply with the new rules. Well, why haven't you, Gov? Here's why. There's a couple things in the new guidance that we don't like. Regarding cleaning and disinfecting. They put in there that like in between each showing, you have to do a complete disinfection and cleaning of the property, like including the bathrooms. Well, that's ridiculous, isn't it? I mean, the people coming onto the property, they're not using the bathroom. You're not letting them use the bathroom, and they're wearing gloves and they're wearing a mask, so they shouldn't be going in the bathroom anyway, unless they really have to. In which case, yeah, you're gonna wipe it down probably. And the other thing it said is, you know, in periodic deep cleaning of the property. This was really aimed at commercial properties. It wasn't aimed at residential properties. So, and also said that everyone comes into the property should wash their hands when they get there. Do you really want that? Don't you want them to wash their hands before they get to the property and put on the gloves? So when they come in the property, they got gloves on. You don't want them going in the bathroom and washing their hands. Anyway, the point is this. We are pushing back against the State Department of Public Health and I think we're going to have some success trying to get that modified. We're waiting for that before we update the best practices to include the other stuff that I said that we're not fighting. So technically, if you want to ask me today, Tuesday, May 12th, what am I supposed to be doing? Well, in the guidance that they came out with Thursday night is in effect. So theoretically, in addition to doing everything I just said, the normal stuff, plus make sure the occupants aren't there and leave the doors open, technically the guidance is in effect and you're supposed to be doing this cleaning. I don't know if anyone's going to do it. As your lawyer, I can't say don't do it. I'm just saying subject to change very quickly. So you're supposed to deal with what you got to deal with. Okay.
So Gov, we've got, I'm sorry to interrupt. We've got a couple questions. It sounds like C.A.R is going to be putting out updated guidelines once you guys figure everything out. So that's been asked before. So keep a lookout on that.
Right.
Where can the text of the California order be found? The DRE actually emailed out the guidelines yesterday, I believe.
Yeah.
Okay.
I mean, that's what it is. You can read it and look at it if you want to. I mean, or you can just wait for us to summarize it in the best practices. Like I said, they took most of our best practices that we already had anyway. So
Yeah.
it's not going to be that different. But like I said, it's going to be sort of reformatted a little bit. It's going to you're going to be pretty familiar with it. But we're just trying to fix the cleaning part because we don't think it's smart or makes sense or anyone's going to do it anyway. Plus, they're trying to put the burden on the listing agent, and you definitely don't want that. You want it on the seller. So stay tuned for that. Open houses are still not allowed. And there's been some confusion on that. I know why, because something in that guidance says no open houses and then semicolon, but you can have people come to a property by appointment or digital sign in. And some people read that to read, oh, great, I can have an open house as long as they sign in advance. No. I mean, here's what you can do. You can have multiple showings on the same day, but at any given time, it can only be, one buying party at a time, like 2 people, and you'd have to clean it after each one. So if you want to call that an open house, right, and line up 10 people in a row and clean the house between every single time they come in, if that's what you call an open house, I guess that's what you call it. But that's not what I call an open house. An open house to me is you don't have to sign up in advance, and you don't have to, and you have multiple people in there at the same time. You don't have to clean it each time. No, the basic rule of any set of buyers is in between every set of buyers, there has to be some cleaning. Now, we're okay with the way it's up until now. It's sort of been after each showing, you're going to wipe down, the doorknob and maybe the surfaces and any light switches that people touched or anything like that, even if they're wearing gloves, just to be safe. It's the new guidance that it has to be a thorough cleaning and disinfecting, including the bathroom. That's the part we don't like. That's the part we're pushing back on. But that's the part technically that's in effect right now. If you really, as a lawyer, have to ask me that question. Okay. So anyway, that's the big picture on that. For now, I just say do what you've been doing. Make sure the occupants aren't there. Wear the gloves. Wear the mask. Sign the PEAD form. Sign the PEAD form. Remember what the good thing about the PEAD form. Not only is it required now, but everyone's agreeing that they're following the rules, and if they don't follow the rules, they're acting against the advice of the broker. Meaning, if something goes wrong, you can't get sued because they all agree they're following the rules, and if they aren't following the rules, they're going against your advice, and they assume the risk, and they assume all the risk. So that's why I've been pushing this form for 2 months anyway. It's a really helpful form for you guys, but now it's really even more important. Now, another form that's not required, but I like, and I think it's a good thing, is the coronavirus addendum, the RLACAA. That's the form, like it says, it's an addendum to the listing agreement. It's the listing addendum. The RLACAA stands for Residential Listing Agreement Coronavirus Addendum or Amendment. So if I were an agent, I'd make my sellers sign this when I took a listing, because the seller is saying, yep, I'm going to follow all the rules. I'm going to require a PEAD form from anyone who enters the property. I indemnify you, the broker, if anything goes wrong. I also understand that you, the broker, are not the police. You're not the one who makes sure everyone does what they're supposed to do. If they don't do it, they don't do it. You can't blame me. Well, why didn't you make them do it? You told them what the rules are. You asked them to sign the form, and that's that. So once again, it protects you legally. It's a good form. You're following all the rules. You're going to get your E&O insurance covering everything. So the PEAD form is pretty much required now. The RLACAA, the Coronavirus Listing Addendum, is just a really good idea that you should use. So those are 2 forms to talk about. I just want to talk about a couple more forms. Another form that's not required. Oh, by the way, before I go on, we got a lot of questions on the PEAD form. Remember how it works? I mean, if I'm a buyer, right? I fill out this form and I'm saying, I promise to wear the gloves and do that. I follow 6 feet apart when I'm on the property and don't touch things. And I'm also stating on that form, I'm not, as far as I know, I'm not currently sick. I have not been in contact with someone who's sick in the last 14 days, and I don't have any symptoms of being sick. So you know what that means, though? You need a new form every day because your health situation might change. So if I'm looking at your house today I'm going to give you my PEAD form today. I'm going to give it to you, the listing agent. If I come back and look at the same property tomorrow, I'm going to bring another one, dated tomorrow. It's always got to be dated the day you're entering the property. Now, on the seller's side, they just have to sign one, listing agent signs one, and the rules don't even say you have to give it to the buyer or the buyer's agent. If they want to see it, you want to show it to them, see, yep, I signed. And you also obviously have to disclose as a seller or listing agent if you have any health issues. And if they want a copy of your PEAD form, you give them a copy. What the heck? But on the buyer's side, not only do you have to sign one, it's got to be dated today. You've got to give a copy or electronically to the listing agent each day. And you should really put the address on the property that you're looking at. I know some people put on there any California property because they want to use the same form on different properties. Technically, you really shouldn't. You should have you should have the address of the property on the one you're signing. Well, what if I want to look at 3 houses today? If you want to, you could write 3 addresses and give one to each listing agent. But what if you don't want every listing agent to know all the other the properties you're looking at? Well, then you're going to do one address, one form per visit, you know? And remember, this is not just buyers and buyers agents, it's inspectors and appraisers and stagers, and everyone who goes on the property should be signing the form and following the rules. Okay, all right. 2 more forms real quick. There's a form we also have called the Coronavirus Addendum, CVA, not a required form, but it's a form that, here's how this one works. Let's say I'm the buyer and you're the seller, right? So I know going into the deal that sometimes things aren't happening as quickly as normal. Sometimes, you know, the appraiser takes extra time, the lender takes extra time, the notary takes extra time, the inspector takes time. Or sometimes things can happen in escrow, like the buyer, someone gets sick or the seller loses their job. Anyway, things can happen in escrow that affect my ability to perform on time or to perform at all. So if you and I agree to this CVA, Coronavirus Addendum, as an addendum to our contract, we're both agreeing, me the buyer, you the seller, that if something happens in escrow related to COVID-19 that's causing a delay, then we've agreed up front that there's an automatic extension. We don't have to negotiate an extension. We've agreed that there's a 30-day extension, either of the time for the buyer to remove contingencies or just a 30-day extension to close. So the advantage of that is once we get into escrow, if something happens, we don't have to try to negotiate an extension. We've already agreed to it. And there's a form that goes along with that called the NUCC, the Notice of Unforeseen Coronavirus Circumstance. So the way it would work is, I'm the buyer, you're the seller, we've agreed to this CVA, Coronavirus Addendum, to our contract. Sure enough, we get into escrow and I'm having a delay with the lender, so I can't remove my contingency on time. So I submit to you the form, the NUCC, the Notice of Unforeseen Coronavirus Circumstance. And as soon as you receive it, that triggers the extension that we already agreed to. And then, okay, now what happens if after the extension, I'm still not ready or you're not ready? Well, we can either negotiate another extension, or it says on that form, either the buyer or the seller can cancel immediately. So the next question is, if we cancel under those circumstances, does the buyer get their deposit back or does the seller keep the buyer's deposit? Okay, interesting. Well, on the form itself, the Coronavirus Addendum, you can either, if you don't check the box, buyer gets their deposit back. If you check the box, the seller keeps the buyer's deposit, if the contingencies have been removed. So now I know what you're thinking. Well, the buyer's always going to want it to say, I get my money back, and the seller's always going to want it to say, I get the buyer's money. Well, you know what? You're right. And sometimes the buyer and seller are not going to agree. And you're not going to be able to use this form if they don't agree, right? Which leads to the next question. If I don't use this form and I'm the buyer and I go into escrow and I lose my job or the lender's delayed or something happens to delay the process and I can't perform on time, and the seller, let's say I've removed my contingency and then I can't close on time, so the seller cancels me, as they have the right to do. Are they going to keep my deposit or not? if I didn't use this form, what's a judge going to say? Well, it's interesting. California law has this civil code section 1511. Some people call it the act of God law. Some people call it the force majeure law. This law says that if you're in a contract with somebody else and something happens, the wording is some irresistible, superhuman fact or act, event occurs, then I can get out of my contract with no consequence. Earthquake, fire, what about a pandemic? Our judge is going to say, well, yep, your excuse is what happened was caused by the pandemic, so you can get out of the deal and here's your money back. Or the court's going to say, no, you still got to perform, you're going to lose your deposit. See, we don't really know how the courts are going to react to this yet. There's already cases starting, believe me. And it might depend on the circumstance. Some judges are going to say, well, yeah, you lost your job because of COVID-19. You're freed from your contractual obligation. But maybe what if the buyer says, well, I didn't lose my job, but I'm worried about losing my job. Or my stock market portfolio went down, so I feel uncomfortable, so I want to cancel the deal and get my money back. Is a judge going to say, based on this civil code, you get your money back or not? We don't know. That's why I'm saying I like the CVA form, because at least the buyer and seller can negotiate this up front. So anticipate this situation and deal with it. But you don't have to. The form is not required. It's just a helpful tool if you want it in your transactions, okay? Before I go on, I think there are questions on what I've just been talking about. So let me cover.
There's a couple of questions I can help you go through because I've been monitoring them.
All right, good.
For the PEAD form, just a reminder, everybody needs to sign one. It's now mandatory. And it's a good idea to sign, or you should sign one before you go in every single time. So if you're going in one day, you're going in the next day, you should sign it.
Yes.
Does the seller need to initial every single buyer PEAD that comes in?
You don't. Here's how it works, right? Let's say I'm the buyer and I'm coming to look at your listing. So I'm required to give you, the listing agent, the form. The seller doesn't have to sign it at all. In fact, the listing agent doesn't really have to sign. I, as the buyer, may say to you, the listing agent, could you please initial it and give me a copy back so I have proof that you got it? I mean, that's up to me, right? If I don't really care, if I just trust you, here it is. Yeah. Seller doesn't have to sign it. Listing agent have to sign. Remember, seller and listing agent, you got to sign your own PAD. But you don't have to sign mine. I'm entitled to you acknowledging receipt and just giving me back a copy if I want that, but you don't have to sign.
What about on vacant properties?
Yeah, same rules apply.
Okay, there you go.
Yeah.
Let's see. For a lease listing, is the COVID-19 addendum form still the same, or there's different lease forms?
Very good question. Yeah, so I've told you about, we have the PAD. We also have the PAD for lease properties, called the PAD LR for lease rental. And that coronavirus addendum form, I said, we have that for leases also, the CVA LR, and then the NUCC LR. As far as the one form I mentioned, the coronavirus listing addendum, you can use that same form for a sale listing or a lease listing.
Got it. Let's see. A good question, maybe for clarification for some people. When do you submit the NUCC form? Is it at the time you submit the offer or during escrow?
Typically, I mean, think about it. That's when something happens during escrow that causes a delay. So you're going to give that form to trigger the deadline that occurred, the problem that occurred right in the escrow. I guess theoretically you could attach it to the offer, in which case you're basically telling the seller right up front. That's another way of just asking for a longer escrow or a longer deadline to do what you have to do. You're telling right up front, yeah, here's the contract. I've attached this to point out to you, because of COVID-19, I want an extra number of days to do this. But you could just write that in the offer itself, give yourself more time. So typically you're going to submit that form in escrow when the unforeseen coronavirus event actually happens. Okay.
Got it. On the PAD again, is the buyer's agent, do they have to sign a separate one, or is their signature or initial on the bottom of the buyer's PAD sufficient?
Yeah, another good question. Theoretically, right, each buyer and each buyer's agent, everyone who enters the property should have their own. But I guess if I'm a buyer and I have an agent and both of us, neither one of us are sick, right? Neither one of us have been in contact with someone who's sick, we could sign the same form because we're saying the same thing. I mean, there is room on it. You can have, it doesn't have to be specific for each person. But I like that. But yeah, if you want to save a piece of paper, save a document, sure, they can, as long as they both have the same health, because remember, everyone who signs it is making a health declaration. And if you have the same health situation, yeah, you could sign the same form.
Now, what if you have somebody who's refusing, either a tenant or a buyer refusing to sign the PAD?
Yeah, two different things. If someone on the buyer's side is refusing to sign and I'm the seller or the listing agent, I'm going to say, why aren't you signing? Are you sick or something? Are you not going to follow the rules? What are you going to do? I mean, why are you reluctant to sign? Well, that's what I've been saying up until 2 days ago. Now I say, well, you really have to sign. But still, what if the buyer says, I'm not signing? What if the inspector says, I'm not signing? I'm not signing. Well, then ultimately it's up to you, the seller and the listing agent, to decide if you're going to let them in or not. I mean, you can say no, or you can give them their own, maybe they don't have a mask, so you can give them a mask. I mean, everyone's supposed to supply their own stuff, but if they don't have it, you can give it to them. But if they refuse to sign, it's sort of up to you how to handle that. Now, if the tenant doesn't sign, I'm assuming you mean the tenant who lives there. So if I want to go into a house that's tenant occupied and the tenant's refusing to sign the form, I'm going to be wondering, tenant, are you sick or something? Why are you reluctant to sign the form? Because by signing the form, all you're saying is, I'm not sick and I'm going to clean it after, I'm going to at least wipe it down or something, clean it after each showing. So yeah, I'd be curious as someone who wanted to come to the property if the tenants, why they don't want to sign it. Which leads me to another question. What if the tenant just says you can't come in? I live here, I'm a tenant, I'm scared of this disease. I refuse to cooperate with any showings of the property. Is a tenant allowed to say that? No, unless they're sick. But what if the tenant's over 65 or has a underlying condition? Well, then they're probably within their rights to not allow someone to come in, if that's really true. And that complicates things as well. But let's say it's a normal tenant, just won't let people in. Are they allowed to do that? No. So what can I do with that tenant who won't allow someone in? Well, normally I'd say you can evict them, but not right now you can't, because we have a little problem in California. And the problem is the courts are closed until August 1st for evictions. You cannot evict anybody for any reason, commercial or residential. Even if you have a legitimate reason to evict them, you can't. Now you could tell this tenant, hey, if you don't allow this, you're screwing up my sale. That could blow the sale, which will cost a lot of people a lot of money, buyer, seller, agent, and we're going to sue you for all the damages you're causing by your refusal. Same issue. What if you're trying to sell a tenant occupied property? Yeah, someone just asked me right now. What if you're going to give them we want to give them a 60-day notice to leave, right? And you can do that in California. If it's a single family home, you're not under rent control. If it's a newer building, you're not under rent control. And even on an older building, if the tenant hasn't been there for at least 12 months, you can certainly always evict them with a 60-day notice. Even if they've been there more than a year, you can evict them if the buyer wants to move in or you're going to do a modification. So assuming you have the right to evict them, you can give them a 60-day notice. What happens if they don't leave after 60 days? They're in violation. You can sue them, you can threaten them, but you can't physically get them out until August 1st. So that's a little problem we're all dealing with here in the rental situation in California. And then to complicate things, some cities like where I live, Los Angeles, have said, not only you can't kick them out till August 1st, but they don't have to pay back the back rent for 12 months. And LA has a rent freeze also, that all landlords in LA can't raise rent, even if whether you're under rent control or not. So you better than me, and I could figure out for you, whatever city you're in, Long Beach, and I don't care where you are, a lot of cities around the state have passed their own rules on protecting tenants, never protecting landlords, protecting tenants. And we, at the legal hotline, we can help you. We have a chart on our website at C.A.R.org. You just go to C.A.R.org and you type in the search box, eviction moratorium chart. It'll show you every single city in California, what the rules are in that city, if it's different than the state rule. So there's that going on. To complicate your life, not only do we have these rules on showing properties, we have rules on tenants and evicting tenants and limitations on evicting tenants. There's the big state August 1st thing, but then there's also the there's the local ordinances. By the way, one more thing. There's only two more forms I want to tell you about related to COVID-19, and that's related to this rental situation. The rental situation is tenants, okay, you can't evict a tenant legally, right? And here's the first thing. You can't evict a tenant legally till June 1st or August 25th if your property is secured by a federally related loan. Or if your property is securing a federally related loan until July 25th. So in other words, and those, you can't evict the tenant if the reason they're not paying the rent is because of they have a loss of income related to COVID-19, but they have to prove to you that they've really got this loss of income. So the last two forms I want to mention is if I'm a landlord, right, and my tenant didn't pay me the rent on May 1st, I know I can't evict them, but to preserve my rights to be able to evict them, I'm going to send them this form called the NTAP, Notice to Tenant About Ability to Pay Rent. And this form tells the tenant, hey, I noticed you didn't pay the rent. You know, if the reason you didn't pay the rent was COVID-19, you have to prove that to me in writing. And then the form that the tenant can use to respond to me and tell me and prove to me why they didn't pay the rent is called the RPD, the Rent Payment Delay, RPD. So these aren't mandatory forms, but they're helpful in this process because as a landlord, I want to preserve my rights against the tenant and because if they don't prove to me that that's the reason, that's going to affect my ability to get late fees and penalties and damages. So anyway, I recommend doing it. But remember, even whether they have a hardship or not, whether they legally have the right to delay eviction or not, as a practical matter, you can't evict anyone in California until August 1st anyway. But you may have various rights about how much damages you can be able to collect from them. And some cities like LA have actually given them extra time to pay back the rent that they couldn't pay because of COVID-19. So you have to, if you're a landlord or a property manager, or you have a client who is, they need to also be aware of the rules in the city you're in. Feel free to call the legal hotline or check that chart. Remember, C.A.R.org, at the very top, there's a search box. You type in eviction moratorium chart. Another thing, we have another website called CAR.org/coronavirus. And on that form, there's a list of all the local ordinances like the Long Beach ordinance and the Anaheim ordinance regarding the rules on showing that I just mentioned. Because remember, cities can still be stricter than the state. Bottom line is they're all pretty much the same now. So what I've told you already is pretty much all you need to know. And let me, as the last time, to repeat the forms that I mentioned 6 forms, right? The coronavirus addendum, listing addendum, RLA-CAA, which is recommended. There's the PEAD form, the Property Entry Advisory and Declaration, which as of 3 days ago is mandatory. Then there's the coronavirus addendum and the Notice of Unforeseen Coronavirus Circumstance, the CVA and the NUCC, neither one required, helpful. And then in the rental situation, there's the NTAP, Notice to Tenant regarding ability to pay rent, and the RPD, Rent Payment Delay form that the tenant responds, neither one mandatory, helpful. Okay, So that's what I wanted to tell you about the showing rules, and things are going to be updated very soon. We're going to update the best practices very soon. I've
Can I
told you
ask you
about,
one more
of
question
course.
that's been coming through in the chat a
Yeah.
bunch in the Q&A?
Yeah.
Is in regards to showing how many people can go into a property at once, and what about if there's children?
Yes. Very good question. Okay. Up until now, the rule has been one agent plus two buyers. The new thing that came out, and if your city still requires that, that's the rule. The new thing that came out, it doesn't say that specifically anymore, but it refers to like a buying party. What if there's 9 people in your family? Is that still going to be okay? We're going to get clarification on that. I think the answer is still going to be, and the answer I would say today is still one buyer, one agent, two buyers. Okay. What about children? Well, the reason I don't like the idea of children coming onto the property is because everyone who comes on the property is supposed to sign this declaration, right, regarding their promise to follow the rules and their contact with 6 people. Does a 5-year-old, are they really going to promise to follow the rules? A minor child doesn't really have the legal ability to sign a form like that and make that type of representation. So if it's at all possible, please try not to have minor children being part of the buying party, because it's really unclear how they can sign this form legally. I mean, if it's a single parent and they got 1 kid and no one to watch the kid, and there's no one who can stand with the kid outside the property while you're showing it, you can't arrange for that, you got to do what you got to do. But I'm just saying, ideally, you don't have the kids, right? Okay.
One last question
yeah.
regarding the PAD, and then we can move on to something other than the PED. But
it's very important, very important.
It is. Once the seller, they were under the impression that once the seller signed the RLA-CAA and the subsequent PED at the time of the listing, they didn't need to sign each and every PED presented by those wanting access, correct?
That is correct. That is correct. Remember, the seller doesn't have to sign anything. If I'm a buyer or a buyer's agent, I need to give you my PED, and I may ask you to acknowledge receipt.
Mm-hmm.
Also, the seller, just the listing agent, I may say, could you please acknowledge receipt and give it back to me with your initials on it, so I have proof that I gave it to you, and you can't come back later and say I never gave it to you. But the seller doesn't need to sign the buyer's PED. Listing agent doesn't even need to sign. They just need to acknowledge receipt if I want that, if I even care. Okay. All right. We can come back to this. Let me talk about a couple more things. Since I promised I wasn't going to just talk about COVID-19, there's a couple other things happening out there, but I'm going to go back to COVID-19 in a second. First of all, a couple new forms. Every year we have new forms in June and December. June's coming. No more COVID-19 forms, but 2 brand new forms are coming out. Neither one's required. They're both good. One is called the Property Visit and Open House Advisory, PVOH, Property Visit Open House Advisory, once we start having open houses. The idea is this is a form I might give to any buyer who comes onto the property, because by giving them this form, I'm telling the buyer, when you come onto someone else's property, there might be things on the property like a loose step or a bump in the carpet that's hazardous that I'm not even aware of. I'm putting you on notice. You be careful. You watch out for yourself and your children. And this form also says, be warned when you go into someone's property, that property, for all you know, may have hidden cameras and microphones. So be aware when you're on someone else's property, you may be being recorded. Now, yes, the seller is supposed to disclose to people entering the property if there are hidden cameras or anything like that, right? But some sellers don't. And then the realtor gets sued. And this is sort of putting it on the buyer and saying, it's your job. I want you to understand the risks of going onto someone's property. You understand that, you accept that. In other words, you're not blaming me. I of course, have to tell you what I know. But a lot of times the agent, you don't know for sure anything on the property that's risky or whether they have cameras or microphones. So it's just a protection for the realtor. The second form is another advisory that protects the realtor. It's called the square footage and lot size advisory. So it's the SFLS, square footage lot size advisory. Because you know, every buyer in the world is going to ask you, what's the square footage here and what's the lot size? Did you know there is no such thing as the square footage? It's a matter of opinion. And the assessor has an opinion, the appraiser has an opinion, the builder has an opinion, the architect has an opinion, the seller has an opinion, the HOA may have an opinion. What's the right one? There is no right one. So the thing I like about this form is you're giving it to the buyer and saying, square footage is, different people have different opinions. If you want to get your own investigation, I recommend it. I, the broker, have not verified it. I haven't measured it. And there's a nice chart on this form which says, you know, like assessor, appraiser, seller, builder, and you can write down what everyone's opinion is and give it to the buyer and say, see, there's various opinions here. Take it for what it's worth. Do your own measurement if you want, but don't come back and blame me and say, you told me it was 2,300 and I moved in. It turns out it's 2,100. That's not what happened. I mean, yes, you know, it already says that on the statewide buyer and seller advisory and the buyer inspection advisory. But now this is a unique form that just covers this. Plus it has a nice chart where you can put in everyone's opinion if you want to.
Like
Same thing on lot size. What if the client says, what's the lot size here? And you know what the answer is? Get a survey. That's the only way you know. And that's the only way you know if that fence is on the boundary line or those hedges are on the boundary. So you're basically telling the buyer, you know, I don't know what the lot size is and I don't know where the boundaries are either. I'm advising you to get a survey if you're interested in finding out for yourself. So I like this form. It can't hurt. It's helpful. Other changes that are happening is on the listing form and the SELM form, the seller exclude listing from the MLS, those are now going to reflect the clear cooperation rule that you're all familiar with, that your MLS has adapted. And I don't even have to go into that. I'm not the big expert on that. You know who's the expert on this? Your MLS. If you have any questions about the whole idea of if you do any public marketing after, you know, after taking the listing, you have to put it in the MLS the next day. There's an exception for marketing within your brokerage. If you have questions on any of this, talk to the MLS, because the MLS makes the rules and enforces the rules. And as long as the NAR approves the MLS rules, then those are the rules. It's got nothing to do with me or C.A.R. They enforce the rules. So ask them the rule, but you'll notice that the form has changed, okay? So there's more explanation on the listing form and the seller exclude listing from the MLS form, okay? All right, a couple more things I want to talk about. Foreclosures. There's something going on right now called foreclosure forbearance, and there's also something called foreclosure moratorium. Those are two different things, but they work together. The moratorium means in California right now, no foreclosures till June 23rd. So if you're not paying your mortgage, they can't foreclose on you. But on June 24th, they can foreclose on you and you have to make up all the back payments unless you're eligible for foreclosure forbearance. You know what forbearance? That's a fancy word for you can delay your mortgage payments. So what does that apply to? That only applies to federally related loans. So if the loan that you're responsible for is an FHA loan, a VA loan, or just a standard conforming loan that's administered by Fannie Mae or Freddie Mac, not only you can't get foreclosed on till June, even after that, they have to work with you. You're allowed to delay these payments. They got to work with you on either a modification or simply delay these payments for up to 12 months. You have to pay the money back. It's just like tenants. You have to pay the rent eventually. And on this program, you have to pay the mortgage, but on a federally related loan, you're entitled to apply for a forbearance and they have to work with you. They can't just require a lump sum payment on June 24th that you got to pay all the money back you haven't been paying. if the reason you haven't been paying is related to the coronavirus. But if it's just a regular loan, you just borrowed money from Wells Fargo or something, or Long Beach Savings and Loan or something, you just borrowed, it's not a Fannie or Freddie, it's not a conforming loan, you just borrowed money, there's a foreclosure moratorium, but on June 24th, you owe all the money and they don't have to work with you on a forbearance, okay? What else? DRE, what's up with the DRE? Well, I think they're gonna open up on May 15th. They're closed now for giving exams, but I believe May 15th is when you're gonna be able, which is like 2 days from now. You're gonna be able to have exams. Plus, if any of you guys have deadlines, like my license renewal is due on June 1st, guess what? You can add 60 days to that. Any deadline you have that's going to occur prior to July 14th, you can add 60 days to your deadline. But if your deadline's July 15th, it's still July 15th. Here's another new thing that happened last Thursday. Let's say you're a real estate brokerage and you want to open up your office. You want all the agents to come back to work and you want to allow the public in. Well, as of Thursday, you are allowed to open your office, but to open your office, you have to follow new guidelines. We sent an email to every single broker in California yesterday attaching the new guidelines. We actually gave you a template. If you adopt our template, you don't have to come up with your own plan. You can just follow our plan. But if I'm a broker and I got a real estate office and I want to let my agents come back in, all of them, and allow the public in, I got to follow this plan, which means you'll see it. If you haven't got it, call the hotline and we'll send it to you, but you got to contact information, you got to train your employees, you got to configure the office so nobody's too close together, modify the break room so people don't congregate. At the reception desk, if you're allowing someone to come in, you have to put some barrier there between the receptionist and the public, or either plexiglass or something to be safe. If you're going to have meeting rooms, if you have people meeting in the office, social distancing and wear the mask, cleaning protocols. It's kind of complicated. It's almost, to me, I don't even know if it's worth it to open my office to all the agents and the public, but you can now. But you just have to follow these protocols and rules. And if someone enters the office that you know is sick, you have to deal with that. It's kind of complicated. You have to deal with that. But yes, real estate brokerages are, as of last Thursday, are allowed to open up. You're one of the businesses in stage 2 that's allowed to be open. You don't have to be. I recommend you do as much virtually as you possibly can, but you can open your office, but you got to follow these guidelines. So there's new guidelines for showing properties that are pretty much the same as the old guidelines, and we're going to update our best practices. But the guidelines for opening your office are brand new, and they're not going to be changed. We're not like negotiating with the government to fix those. Those are what they are. They're not going to budge on those. So we got to deal with those. The other ones, I'm optimistic on the best practices. We're going to get them, so we're okay with them. Okay. Let me see if there's anything else I really want you to talk. You have more questions, by the way? You can.
I have a ton of questions.
Go ahead.
So let's talk about if somebody has had COVID, a seller or something, how are you supposed to disclose that if they've recovered, and what's the best way to disclose that?
That is such a good question. I mean, first of all, before I get to that question, if the current seller or the current occupant has COVID, of course you have to disclose that. And by the way, let's say there's a buyer coming on the property and they're not sick, so they sign the PED that they're fine, and then 3 days later the buyer gets sick. So apparently they were probably sick at the time they came on there, but they didn't know. That buyer is supposed to, it says under the rules, is go back to the listing agent and say, I didn't know this, but I guess I was probably sick when I came onto your property. In which case the listing agent is supposed to go back to everyone who entered the property after that buyer and tell them, which is another reason why you collect the PEAD form. But the question I was asked is, what if the seller or the occupant had the COVID-19, they don't have it anymore, and now they're selling? do they have to disclose to the buyer that the previous occupant had it and doesn't have it anymore? Or would be disclosing that would be an invasion of privacy of the seller or the listing agent? That is such a hard question, and we don't know the answer. And we're not going to know the answer. We're probably going to try to get a law passed to clarify that. Otherwise, we got to wait for a court case. But if you ask me, okay, Gov, what's the answer today? If you don't have a law and you don't have a court case, should I disclose it or not? What's your gut reaction? How courts are going to react to this? And my gut reaction, the courts are going to say you need to disclose that. And that's the best I can do for you right now, is give you, and it's not just my opinion, that's C.A.R, legals. And we sort of talk to a lot of real estate attorneys out in the world, and that's sort of the consensus view. Until we get that clarified, I think you should disclose it.
Okay. As a broker, I agree.
Yeah.
So, there are a handful of very specific questions. My recommendation would be for these very specific case by case is to call the C.A.R's hotline to get a better.
I'll even give you my email, because I have nothing better to do these days than answer emails, and that's govh@car.org. My name, Gov, G-O-V-H @car.org. Yes, Victoria, I agree. When in doubt, disclose. So yeah, any questions we don't get to today, or your specific questions, call the legal hotline or email me. But if there are any more general questions, can
we go back to geez Louise, posting the PED or somewhat reform? Right. Where do you post it? What should be posted?
Yeah, I mean, we're trying to get clarification on that, but right now it says you must post on the front door or near the front door of the property being shown a copy of the rules that you have adopted for showing properties. And remember, the rules are the PED form. In other words, you don't have to you can create your own rules if you want to. You could hire an expensive lawyer and go through this guidance and create your own rules. But if you want to, you can just use the PED form. We verified that what's on the PED form constitutes the rules, which means that's the form you can also post. Since it qualifies as being the rules that are required, it also qualifies as being the thing you can post. Now, we may actually tweak it a little bit just to make it more visually attractive, but for now, yes, you can post it on the door, next to the door. I don't think it really matters.
Okay. Is the PED form required on commercial showings as well?
Not 100% clear, so I will say yes. When in doubt, yes.
When in doubt, yes. Let's see. So one thing that was kind of put on the back burner for a while is the legislation looking at including independent contractors for the required sexual harassment training?
That hasn't been done yet. Sexual harassment training is only now for brokers and W-2 employees. But remember this, the rules regarding sexual harassment apply to independent contractors. So it's not a bad idea to take the class to find out what the rules are so you know what not to do. Plus, I will point out to you, this year, 2020, the rules got tougher, much tougher. I have to take the class every 2 years because I'm a boss at C.A.R. And I said, whoa, things have really changed in 2 years. So it's not a bad idea, because if you do something bad in the office, you're guilty whether you're the boss or not the boss. So independent contractors, we all should take these classes to find, I mean, things you probably thought were innocent and were probably okay 2 years ago are not okay anymore. I mean, it's even got so strict that you're really not supposed to do something called abusive conduct. You're not allowed to call people names, even if it's got nothing sexual about it. Have you ever had a coworker you just didn't like, and you say, "Hey, you big stupid dummy"? That was okay last year. That's not okay anymore. That's abusive conduct, even if they deserve it. So, yeah, you don't have to take the class. It's a good idea. By the way, one more thing. There's realtor relief efforts out there that you should apply for if you want to. There are 3 of them, and now there's only 2. There's the PPP, the Payroll Protection Program, the EIDL, Economic Injury Disaster Loans, and the PUA, Pandemic Unemployment Assistance. Forget the second one. They're out of money. It's not coming back. So let's talk about the other two. PPP, Payroll Protection Program. You may be eligible, whether you're the broker or an agent, to apply for a forgivable loan that you don't have to pay back to replace 2 months worth of the business expenses or lost income. But there's a limit on how much it can be. It's 2 months worth, and you have to demonstrate 2 months last year you made this much as opposed to this year, and you have to spend the money by July 1st. The other one that might be better for agents is called the PUA, Pandemic Unemployment Assistance. This one they're not going to run out of money for, and it's retroactive. Even if you haven't applied yet, you can apply now. It's retroactive back to February 1st. And the way it works is, I mean, if you're still making money, closing deals, making commissions, you're not going to be eligible. But if you're not making money or you're making less money than normal, you're going to be eligible for this. C.A.R. a week or so ago sent to all of you a step-by-step how to fill out the application to the EDD. If you didn't get that email, or you have questions on filling out the application, or you have questions on the PPP form, please call the relief hotline. Don't ask me, but ask the experts that we have at C.A.R. and the number is 213-351-8450, 213-351-8450. It's different than the legal hotline. It's a different hotline. And also remember that the special website I mentioned, CAR.org/coronavirus. It has a lot of FAQs about this as well. They can help you. They will help you with and we know a lot of realtors who are starting to get the money now, starting to get the unemployment or the PPP loans. You're eligible for the money. Why not get it? Depending on your circumstance, okay? Okay, any more questions?
One last question, and then we can just do a little recap because, and I will say to everybody watching, thank you for your patience. I've slammed with probably over 200 questions. So if your question did not get answered, we were doing our very best. If your question did not get answered, call the legal hotline. Gov just gave you his email address because apparently he's, got nothing better to do.
Yeah.
But in regards to the new form that's coming out in June, the square foot lot size advisory, so should agents not include their lot size on any of their promotional marketing materials?
No, it's fine. It's fine. It's still fine to put your lot size. I would just always put disclaimers on there, approximate lot size or lot size according to so-and-so.
Mm-hmm.
But the good thing is, even if you put the lot size there, then if you give them the form, they can't come back and say, well, you said on the marketing the lot size was this, and you're going to say, yeah, and I also gave you this form that you signed where you acknowledged that the only way to really know the lot size is to do a survey, and you weren't relying on what I said. So yeah, you can still do it there and give them the form. By the way, I see Heather Raphael asked a question again. Tenant renting a house and they keep having family gatherings. Absolutely. If you're the landlord, you can prohibit that and evict them. You can't evict them till August 1st. But yes, you can absolutely say to the tenant, you cannot have family gatherings like this. That's a risk to me. And I'll evict you. And in the meantime, I'm going to sue you because you're breaking the law. I mean, having gatherings at all. I guess if they're all live there, that's one thing, but you start inviting other people in, yeah, I think you can do something about that. Okay.
Gov, will you please share your email address one more time, please?
Yes, it's always dangerous for me to do this, but it's govh@car.org, govh@car.org. Now I get back to everyone, but I'm not guaranteeing today. I'm not even guaranteeing tomorrow. So call the legal hotline. Sometimes I have to catch up on the weekend, but I got nowhere to go, so what the heck.
And then that phone number for the legal hotline one more time, please.
The legal hotline, remember there are two numbers to call. The legal hotline, we have not changed this number for 43 years, is 213-739-8282, 213-739-8282. The brand new temporary short-term realtor relief hotline, which is where you ask your questions about getting the unemployment insurance or the loans, that's 213-351-8450. 213-351-8450. I know what I wanted to tell you. What about if the buyer or the seller is a nurse who works at a hospital?
That's a great question.
And they don't know for sure if they've been in contact with someone who's sick, but it's a strong likelihood, or a possibility anyway. That's why on the PED form, there's paragraph 8 that's blank to put what you wanted. That's where you'd put in something like, I don't know if I've been in contact with someone, but I need to tell you that I'm a hospital nurse, right? So, I mean, you definitely need to disclose that, because you're not necessarily sick yourself. You don't know for sure you've had contact. But if you're like a paramedic or a fireman or something like that, you need to disclose that, and you do that on paragraph 8 of the PEAD form.
Perfect. So for those of you watching, agents, brokers, managers alike, C.A.R. has done a phenomenal job with their coronavirus updates. You can get the updates per city, the city ordinance is on there, literally anything you could ever need. So make sure you go to their website and get that information. A lot of your questions will be answered through there as well. And I think, Gov, I think we're done.
Yeah, I'm scanning the chat, and I think I got most of them. One question to repeat: where do I get the information regarding other cities and their rules for COVID-19? Remember, there are two different things. There's eviction rules and there's showing rules. The showing rules are on the car.org/coronavirus website. You'll see on the front page, you pull there on the right-hand column, item 5.3, it says other local ordinances. And for the information on the rules on rentals, that's on the regular website, car.org. On the search, you're going to type in eviction moratorium chart. And let me see if there's anything else. Yeah, if you have complicated questions, or if you have PUA or PPP questions, don't call up me or the hotline, don't know.
Yeah.
Yeah, it looks like we pretty much got. Judy Tyler, is there a way to find out if the seller is a healthcare worker? Yes, I meant to say that. If you're the seller and you're a nurse or a healthcare worker, you need to disclose that on your PED, and you need to tell the buyer, yeah, I work at a hospital. As far as I know, everything's good, but I need to tell you that I work at a hospital. So yes. Okay.
All righty. Lots of questions. Thank you guys so much for participating. This was recorded, and I'm sure PWR will be sending the recording out within the next week or so. So if you want to revisit all the great information that Gov shared with us today, by all means, please do. Gov, thank you so much for spending time with us at PWR today. We really appreciate it.
My pleasure. Can't wait to see you in person.
Right? Hopefully sooner than later.
Hope so.
All right, everybody. Thank you guys so much for your time. Stay safe, stay healthy, and make good choices.
Thanks, Stephanie.
Thank you.
Bye-bye.
Bye.